Good evening, Council. May I have a mover and seconder to call the meeting to order, please? Councillor Garwood, Councillor Alexander, that the special meeting of Council of November 10th come to order at 6:30 p.m. All those in favor? And that has carried. Councillor, is there any disclosure of pecuniary interest this evening? Not seeing any. At this time, I will turn to a petitioning member. Councillor Fisher.
Thank you. As the meeting, the invite suggests, we're here tonight to talk about what I see as two very pertinent issues that arise from the meeting of the 5th. One, the resolution brought forward by Councillor Anita Moore. That needs to be discussed, and we also need to discuss the firing of our legal representation, Loubser Nixon, and the strong mayor's powers being used in that fashion. I think it's best to start off by talking about the motion that Councillor Anita Moore brought forward, and also the legal opinions we did receive minute by minute from Davies House today. So I'd like to start a discussion with that.
Please proceed.
Thank you. Thank you, Councillor Fisher, for including me in your petition for this. I had brought the motion forward last meeting, and I had tried very hard to not muddy the waters with that. And I wasn't aware until the following day that my motion was overridden by the mayor. So it came as a surprise when I reached out to Deputy CAO Ainsworth about when my motion would be forwarded off to the minister, and was advised that it wouldn't be. So I voiced my displeasure with that, and honestly the interpretation of the strong mayor's powers, and I have struggled with this before. It's not the first time, because I don't see them as applying to every decision that a mayor can make. So I think they are prescribed and they're specific. So I did send the CAO an email and copied Deputy CAO Ainsworth on the email to say that I didn't agree with the interpretation, but that I had left it at that also, and I didn't reach out to anybody else for a review like I thought I might, but I was advised the next day that it would be considered as I had asked to be reviewed and considered, and that it would be. So I was happy with that. But I'll also say that we received two separate legal opinions since then. One legal opinion from our lawyer, Loubser Nixon, saying that the use of the strong mayor's powers in this situation was not appropriate. And then today we received an unsolicited legal opinion with a minute-by-minute breakdown of the meeting, and also stating that the use of the strong mayor's powers for that motion was not appropriate, and that my motion still stands. So I wanted to just bring that up, because I thought other council members should be made aware that I didn't reach out to anybody myself, that these, like I say, one unsolicited legal opinion and one potential solicited legal opinion. I'm not sure if Deputy CAO Ainsworth sent that off, but that accordingly, if this council is willing, we can re-vote. We can put that motion back on the table to make it less muddy and re-vote. I'm happy to do that. Would we waive procedural bylaw to put that motion back on the floor just to clean things up, or leave things the way they are? I'm fine with that. I think the majority of council voted to pass that information along to the minister, and I believe that's been done. So I'm happy either way.
And from clarification, when you say that the information has been passed along to the minister, if it wasn't from staff, how did the information get to the province?
That's just what I was advised.
Deputy Cabral.
Well, thank you, Mayor Coughlin. I think for me it was actually what came out in the news. I struggle with the fact that and this is my opinion, and I'm not a legal guru or anything like that, obviously. However, I did reflect on it a bit. I read some of the legislation in order to better understand, because in my opinion, it wasn't about strong mayor's powers per se. It was about whether or not the strong mayor powers should have been used in that instance. And there were several legal opinions on both sides of that particular fence, which I think actually does create a real dilemma, because there was no clear path. So anyway, I'm just going to kind of draft it up a little bit of an opinion for me, but I believe the mayor's attempt in using strong mayor powers to nullify a clear majority council resolution that directed legal counsel to pursue a judicial review and then further terminate legal counsel afterwards was incorrect. The Judicial Review Procedure Act permits any person with a legitimate interest to apply for judicial review. So the mayor's exercise of strong mayor powers does not extinguish independent access to the courts. So in my view, the mayor cannot lawfully preclude persons or council acting by majority from initiating or supporting a court challenge to a decision that affects the municipality. I also believe that council may properly reaffirm its prior direction, prior notice of motion, as a democratically elected body. Council can pass a clear, recorded resolution instructing the CAO and clerk to preserve the status quo, to retain or direct legal counsel to commence a judicial review application, and to seek injunctive relief if necessary. The majority resolution both protects the municipality's interests while legal issues are being examined and establishes a lawful basis for urgent legal steps. So if the mayor attempts to override that type of a resolution, I would actually expect legal advice to come forth again if required, so that interim court relief could be sought again. So my position is that I would suggest that maybe we do re-vote on all those items. So that's kind of where I'm sitting right now.
Councillor Garwood.
Thank you, Mayor Coughlin. Through you to either the CEO or the Deputy CEO, can you confirm, just circling back to the information that was shared with the province, understanding it's been done, so that's fine, but if you interpret the bylaw that was passed on Wednesday evening the way that I interpret it, that would go against council direction. So was that staff that initiated that information towards the province, or was that council driven?
Deputy Ainsworth.
Thank you, Mayor Coughlin. After the meeting on Wednesday evening, staff, as they do with any direction of council, communicate that direction to the appropriate departments, agencies, whatnot, and that was what was completed. The information approved by council through the bylaw that was proposed by the mayor and ultimately approved, that's what was communicated to the province by staff.
Follow on.
Thank you, Mayor Coughlin, and thank you, Deputy CEO Ainsworth. So from what I'm understanding, not the motion that was presented by Councillor Moore, correct? Thank you.
Deputy Cabral.
Thank you, Mayor Coughlin. I just wanted to, the way I rationalize this is because anybody can apply under that particular legislation for a judicial review. If it was any other person or any other group, your strong mayor powers wouldn't have any effect on them whatsoever. So I'm really trying to figure out how, in your mind, strong mayor powers were able to be used to stop this council from seeking the same thing when literally council is included in that legislation and being afforded the opportunity to do that. So
Thank you. If you could, and I do apologize for on the fly. The resolution brought forward by Councillor Fisher. If I could have that up. Thank you. Councillor Moore.
Thank you. Trying to keep this sort of succinct, so we talk about one thing at one time and not getting things muddy again. What I understand is what we passed for my motion was considered a resolution, and I'm just paying attention now to what our lawyer has stated, and that the strong mayor powers have the ability to quash a bylaw. So that is only just one of the reasons why they're saying that that it wasn't used appropriately. But I really just would like to know, what is the problem with it? What was the problem with the motion that it had to go to such great lengths to not get to either the facilitator or the minister, when 4 members of council, and I didn't know that before the meeting, I put it out there to see who would support it. I did get 4 members of council to support it. And so if that's the case, what is the problem with having 4 members of council's view, and that, and successfully so, when put and aligned with what the county had had put forward as a recommendation that just the day prior? I just don't know what the problem is with that.
I'm finding difficulty, so I'm just going to caution that suggesting that a member of council sought the approval of 4 members of council prior to.
Council meeting there.
No, that was not what was stated.
That's what I've heard her say.
Thank you, and I'm.
Okay, sorry.
Sorry, and I'll correct myself, thank you, because I did not reach out to the other members of council before Wednesday's meeting. And I did, though, put it on the floor the day of the meeting. And luckily for me, 4 members of council agreed with what I had tabled. Let me just be clear.
And
Thank you.
I do appreciate the clarification. And again, the suggestion that it was something that was supported by the county. If we can get clarification on that as well, please.
Yes. When I watched the county meeting, there was a recommendation that staff had put forward to county council. And that's what I looked at. That's what I read. That's where Schedule 3, I believe, included the map. And that's what I was also, when I looked at that, I thought, that is reasonable. It's reasonable. I don't, as you know, I haven't been happy to give up any land. You know, I didn't think that it was necessary all along. But trying to be reasonable, I thought that is the lesser of 2 evils, and that I could potentially support that, along with their recommendation that the servicing for Bayfield Street stay within Springwater, which I've also supported all along. There's no secrets here. That is exactly my position all along. So when I saw that, I thought, well, I could align myself with that. That was my intent. I know that county council did not eventually support that recommendation, but that doesn't mean that we don't have to at least entertain it. So that was my attempt, and I don't know what was wrong with that, and that was my question.
Councillor Fisher, Councillor Garwood.
Yeah, I don't think anything was wrong with that. I actually, when it came forward to council, I certainly was in support of entertaining sending that to the facilitator. We are not the only stakeholders here. You know, there's Springwater, Oro, Barrie, yes, but also the entire county to think about. Their opinions are very important. It should be very important to all of us. We are one of the 16 municipalities that are part of that county. I also have to say that I was under the impression when we left that night that the majority of council put forward something for the facilitator to see, that map. I thought it was very important. I also left here believing that that's exactly what would happen. As is said here in the legal opinion by Davies Howe, as a result of proper tabling, voting process, and clear acceptance, the Moore motion was validly passed. We as a council, an entire council, should be more than willing to share with the facilitator in order to further the process. So I was under the impression that that went forward. I was also disappointed when I found out it didn't. And I think it should stand. I think it does stand, and it should go forward to the facilitator.
Thank you. And for clarification, Councillor Moore, has this motion been sent to the facilitator?
Yes, it was.
And not by direction of council and not by our staff, correct?
Correct.
I said Fisher and then Garwood. Councillor Garwood.
Thank you, Mayor Coughlin. Again, I think we're sitting here relitigating the past as to what we already discussed for multiple hours last evening, and I understand the desire to keep things focused here in this conversation. I agree. I also agree that the county's opinion significantly matters. They are one of the 4 stakeholders in this conversation, but the county chose a different route. Regardless whether some of us like it or don't like it, yes, staff recommended a map, but that is not what the county overwhelmingly supported, was not that map. Secondary to that, and I said it multiple times last week, we were asked to discuss and debate a framework agreement, not make up our own framework agreement on the fly. Through the mayor to Deputy CEO Ainsworth, when I open up the bylaw that passed on Wednesday evening, and I look at page 2, item number 4, it says, notwithstanding any previous resolutions regarding the Barrie boundary discussion, this bylaw shall take precedence. Can you speak to what that line means? When I read that line, it means it doesn't specifically point out Councillor Moore's motion, but it is related directly to any motions that's related to the overall topic. Can you just confirm my understanding?
Deputy CAO.
Thank you, Mayor Coughlin. That is correct. That line within the bylaw is exactly as it states, notwithstanding any previous decision or direction from council. And as a point of clarification as well, I believe from Councillor Fisher, there is no question that the motion was passed appropriately. It was tabled, debated, and passed appropriately. That is not the issue. It is this line item within the bylaw that says notwithstanding any previous decisions of council is why the correspondence was simply communicating that decision of council, as that previous decision was in direct conflict of what was included within the bylaw.
Follow on.
Thank you, thank you, Mayor Coughlin and Deputy CEO Ainsworth. And that was going to be my next point was, yes, I agree with the opinion that was provided. The motion was legally passed. This council did endorse that, but then it revoked it, just as we do often around this table. Going against council direction is concerning in my perspective. There's many things at this table I've disagreed with over the past 3 years, but I don't get to run around and do so. The secondary piece is we talk about our opinion of strong mayors. Again, it is new legislation. I myself have done lots of reading on it, and it is very gray in many areas. I will give you that. But when I go to ontario.ca and I look at the Municipal Councillor's Guide for Strong Mayors, it says bylaw power related to the provincial priorities, that the head of council can propose certain municipal bylaws if they are of the opinion. The head of council. 6 of us can have an opinion about strong mayors, but it is not our opinion in which strong mayors' powers are placed at this table or not. I wish there was an integrity commissioner for strong mayors' powers. This would make it a lot clearer across the province, not just in Springwater, across the province, to provide some guidance. Unfortunately, we have to lean on legal opinions to provide advice, which costs the taxpayer money from whatever perspective you come at this with. So again, the deputy mayor and 6 members or 5 other councillors can have an opinion, but it is not our opinion in which the legislation speaks to. It is the head of council. So if the head of council, as it indicates here in the legislation, is of the opinion that the bylaw would potentially advance prescribed provincial priorities, then strong mayor's powers are permitted. That is what I am reading. Again, not being a lawyer here. Thank you.
Councillor Moore.
Thank you. And just to reiterate that the legal opinion that we did get said that the use of the strong mayor's powers in that situation were not permitted. So that meant that my motion stands. And until that's challenged, we don't know, because again, I will reiterate from weeks ago, there is no case law. There is no precedent setting, municipalities that have gone through this where we can go back and say, in this situation, this is what happened. So there is no case law for us to rely on. And unfortunately, we're creating it. Ground zero is Springwater Township, I believe, for strong mayor's powers. And according to our lawyer that we retained, he said that they were not permitted in this situation, that my motion stood, and he was proceeding as was directed by council during that meeting. That's what we have to rely on. And I'm not a lawyer either.
Follow on Councillor Garwood, and then I do have Councillor Alexander.
Thank you, Mayor Coughlin. And just to add on to Councillor Moore's comments here, we also need to remember, though, that lawyers are not judges. Our lawyer does not write the law, nor does any of the multitude of legal opinions that we have received over the past 3 months, 5 months, 6 months. So I completely respect that the lawyer that the Township of Springwater did seek provided an opinion. Again, that is their opinion. It is a sound legal opinion. We've also had our Township of Springwater lawyer provide opinions that are alternate to other opinions that we have also sought out and paid for from the taxpayer's perspective. So again, yes, we rely upon these opinions, but it is this body's decision, or this body's responsibility to make those decisions. So I don't see how our legal representatives should and could ever go against direction of this council, regardless if they agree or disagree with it.
Councillor Alexander?
Okay, so a couple of things. So with respect to Councillor Moore's motion on Wednesday evening, I too was very much of the opinion that it had passed and it was going through. We had a lot of discussion around this table with the clerk on how to do it, because everyone was confused, per se, on how to make it work with the framework agreement and such. We tabled the framework. We then deferred it so we could get Councillor Moore's motion on the table. We voted on Councillor Moore's motion. Then we went back to the framework. So in my mind, they're two separate things. If they're one thing, then everything above that whole meeting should be done, in my mind, with the logic that was given on why everything previous, right? Like the whole meeting would be null and void in my mind. Now, again, understanding I'm not a clerk, I'm just interpreting the municipal act, but I think what was most disappointing for me is it was very muddy, we were confused, and we were never told that that motion was not going to be moved forward. I think in terms of transparency for not only this council, for the public, that is very important, that everyone understood what happened, because everyone did not understand. I didn't understand, and I know many people that sat there in that audience reached out to me and were not expecting that. They assumed it had gone through. They assumed they were two separate things. So I think that's important, that we are ensuring we're transparent, because quite frankly, we're not being very transparent right now. The second piece with respect to legal advice, yes, it is only legal advice, but came from the lawyer that this township hired. We should be listening to it, and the fact that there's multiple legal opinions, I understand that, as Councillor Moore stated, this is all new. However, all that multiple legal opinions say is you're going to court and they're going to fight it out one way or the other. And that bill goes on our residents, it goes on the taxpayer. So as a council, it is our duty to protect the township from going to court. Not by simply saying, oh, I don't like this legal opinion, so I'm going to get another, or this one says I can. I don't even understand why we're going down this road. We're just opening ourselves up to get sued. And like, why? Why?
Thank you for those comments, and I will turn to CEO Forfar to describe the compensation, or sorry, the suggestion that the Township of Springwater will be footing the legal bill. If you can speak to the most recent resolution, please.
Through your worship to members of council, at this point in time, staff understand that there was a directions from Mayor Coughlin on Saturday that was issued, and at this point in time, that Loopster Nixon has no longer been retained for their services following the veto on Friday. So at this point in time, we are moving down the path with the direction that Mayor Coughlin has provided under strong mayor powers.
Which is that the corporation of the Township of Springwater will not be responsible for any legal fees associated past 12:15 p.m.
Through your worship, that's correct.
Thank you. Councillor Alexander?
So I understand that when we get taken to court, because there are different legal opinions. There's opposite legal opinions. We will get taken to court over this because there is a differing of opinion. The township is going to have to pay that cost. Loopster Nixon isn't paying the cost. When they gave us advice, we didn't follow it and then fired them. The township will be responsible if we get taken to court.
And you are correct. And as the deputy mayor pointed out earlier, anyone has independent access to this challenge. So if someone challenges this, that is their independent right, but it will not be paid for. We will be a defendant, I guess you could say then, but we will not be the applicant. Deputy Cabral.
Thank you, Mayor Coughlin. I think my problem is the fact that you used strong mayor powers to overturn a direction and a resolution of council with respect specifically to that. The Judicial Review Procedure Act provides a lawful means to protect the municipality's interests while the courts consider the legality of strong mayor actions. Council's clear recorded resolution preserves the democratic and legal basis for pursuing judicial review and relative injunctive measures. And I think, we keep talking about taxpayer dollars. I think taxpayers really do deserve to know exactly how we got here, how this whole boundary adjustment came to be. And that was part and parcel. The purpose of the judicial review is to see whether or not you had the ability to utilize your strong mayor powers in order to push the agreement forward. Council members made, I'm going to say, basic pleas to the provincial government to say that, you're asking us to vote on a framework agreement that we've had no opportunity to really change whatsoever. So I'm back at square one. I would suggest to you, Mayor Coughlin, that your use of strong mayor powers to unilaterally cancel Looper Nixon's direction that was provided by this council, I think that's faulty and defective in and of itself. And, I'd actually like to see it happen again. And then if you'd like to fire them again, then that would be your prerogative.
Thank you. Councillor Fisher.
There. Well, I guess we're sort of moving on to the second portion of the meeting. I'll just recap. When it comes to Councillor Moore's motion, I do think that the lawyers' opinions are valid. I do not discount them at all. As a matter of fact, I think that, yes, they are not judges. However, we don't have judges here. We have lawyers and their opinions. They're very expert opinions to rely on. So I certainly don't discount their opinions, particularly the lawyers that or the law firm that we have taken on. Also, I have to say that when our mayor can veto or believes she can veto any decision of council, regardless of legal opinion, it is a bit troubling. And I do believe that transparency is key with our public. However, moving on, since we are talking about the attempted dismissal of Loopster Nixon as our legal counsel, I want to say a few words. One, this isn't a discussion or a debate on strong mayor's powers. I believe that should happen at some point, but it won't be for this council to do. That's a provincial priority. This is to discuss really what I see as the misuse of strong mayor's powers. Many people in the public, really since Wednesday, have contacted me, have discussed this, and even said, what is the point of having a council? What is the point of having a council if we can sit up here, we can vote democratically on any particular issue, and it simply can be vetoed by a mayor, any mayor with strong mayor's powers, not just ours. it is deeply troubling to people, not just in this community, but province-wide. We, as a council, and frankly, even those in the public, should be challenging this. As Councillor Moore said, this is ground zero for strong mayor's powers. Unfortunately, it is legislation that needs to be challenged, needs to be scrutinized. We cannot descend into having one individual on council being able to misinterpret and misuse strong mayor's powers. And if they do go unchallenged, folks, that becomes the precedent that is set province-wide. When the precedent is set province-wide, and we here in Springwater, for example, don't do anything, what happens next time, when mayor's powers, and I'll say it, are abused, right, or misinterpreted? It can't be up to any one individual. I believe that that our mayor, respectfully, did not have the right to veto the resolution. I believe that there was no right whatsoever to fire our unanimously elected legal counsel. I also have to say that that in conversations with people, I believe that under strong mayor's powers being used in this fashion, we in Canada point our fingers at third world countries that misuse power. We sit back and we think we're better than that. Well, I think what we're seeing here is when we give power to singular individuals, it can be misused and abused. I do want to say this, the mayor's authority to veto is limited to bylaws that, in the mayor's opinion, interfere with prescribed provincial priorities. We know this, and does not extend to resolutions or decisions regarding the retention or external legal counsel. Our legal counsel was acquired through all members of council. It is a council resolution. Not one person can go ahead and fire them. So in my opinion, and it's not a legal opinion, but in my opinion, we still retain Lubster Nixon as our legal representation. And in my opinion, that still stands.
The opinion that there's a misinterpretation, a misuse, an abuse is not taken lightly. To suggest that there
It wasn't said in jest.
To suggest that there is an abuse of power, there is also a responsibility to use tools that are provided by the province. So to suggest that there's a misuse, it specifically says if the head of council is of the opinion, if you would like to rewrite your motion that does not have it tied to provincial priority, then I will not be able, nor would I use it. However, when the statement is that everything will come to a halt until such time that the courts have made a decision, that is a delay of provincial priority. And therefore, I am of the opinion that the motion was intended to delay provincial priority, and therefore the use of strong mayors is in effect. Rewrite it, bring it back. There will not be an abuse. There is no abuse. There is no power. There is no parking spot. There is no... Councillor Fisher and decorum. No, this is not providing the opportunity to speak. This is me asking you to allow me to continue without you interrupting.
Point of order. As chair, you can speak at the end.
No.
You are not.
Councillor Fisher, if you would like to open the procedural bylaw and rewrite it to make it so that I can only speak at the end, we can do that. However, I have the opportunity, just as all members do, to speak. And because you don't like what I'm saying, point of order is not stop talking, I don't like what you're saying. And then in which fraction of the procedural bylaw am I out of order?
Mayor,
Which
Mayor,
point?
You're asking me a question, I'm answering.
Which point in the procedural
Mayor
bylaw?
Coughlin, you're stick handling the meeting, right? It's time for other people to speak. I have said my piece, right? I believe it to be true, and yes, I believe there has been a misuse of power here. I've made it very clear. I'm not withdrawing that. So you can chastise me if you like, but I'm sorry. It is a misuse of power, and I do intend to continue with my motion.
And in which point of the procedural bylaw am I out of order?
Mayor Coughlin, feel free to continue chastising me. Go ahead.
So the answer is you don't know. Thank you.
Sure, Mayor Coughlin.
Councillor Alexander.
Okay, so I'm going to take a step back for a second here. I think it's important that the public realizes, because I hear the narrative about Loopster Nixon. This council asked our former CAO to find us legal representation. He recommended Loopster Nixon, not someone on this council. Our former CAO did, and this council unanimously said, yes, let's move forward. That's an important piece for people to understand. What I'm struggling with is why we're firing them. We haven't met. Part of your mayoral directive is to retain external legal counsel without delay to advise and continue to represent in the township with respect to the process and decision-making of the township regarding the Barrie boundary adjustment. So are we asking staff to pick someone who's going to agree with you? Or are we telling them to unbiasedly pick another legal firm? And if that other legal firm doesn't agree with you, are you going to fire them as well?
The motion that was brought forward to seek out exactly what's in there does not exist. This does not permit council from bringing forward another motion to hire Quinto Annabelle of Loopster Nixon. That is the prerogative of this council. However, if it is tied to a provincial priority, the same thing will be happening and we will find ourselves in a circular motion. Councillor Alexander.
You didn't answer my question. If staff comes forward with another legal firm and they agree with Loopster Nixon and say you can't use your strong mayor power, are you going to fire them as well? Because that's what's happening here. You're firing the legal firm that doesn't agree with what you want to do.
And the same could be said that 4 members of council are continuing to hire a legal firm that continues to agree with what they want to do. This is not, we have legal opinion. To suggest that Friday night was not spent until after midnight trying to determine the legality of the actions needed to be taken, that this is just something on a whim, that I would make a decision without ensuring that the corporation is protected. Whether someone or an entity chooses or not to sue our corporation is not a reason for me to not do what's right.
Okay, if you think what you're doing is right, then have at her. I will stand opposed because I need this township to understand that I am willing to stand up here and do what's right for it. And I know I personally certainly don't want to get sued because I've been a part of making decisions that aren't in the best interest of this township. And I have no doubt you were up very late trying to figure out a back door to get your way.
Allegations again by this council of misinterpretation, misuse, abuse, corrupt power, irresponsibility, and backdoor.
I will stand by what I just said, yes.
Is there anything further? Is there a resolution or point to this meeting this evening? If that, I did not call this meeting. I do not have an agenda. There is no resolution. What, if there's anything else that needs to be said, please say it in an open public forum. If not, what is the intention this evening? Councillor Moore.
Thank you. I don't know about a resolution unless that's what this is.
Yeah.
Okay.
I've sent it to the clerk.
There is a resolution or there is a motion? Okay, that's secondary, but I just, to reiterate sort of what Councillor Alexander is saying, I am not in a position to remove Loopster Nixon of what they have done for us so far. I haven't always agreed with what they have said, and you know, I've had to push forward. Originally, I didn't even want to work regarding a boundary adjustment at all. and it was because of Loopster Nixon that we had to sort of work with the facilitator and walk this path a long time ago. And so I haven't always agreed with what they've said, but I think overall, the team has done a great job for us and have gone over and above when we've asked them to produce material at the last minute. They've done everything we've asked. I don't understand also why they're being relieved, or why, maybe if you explained, Mayor Coughlin, what the rationale is behind relieving them of their duties, it would be easier to understand. But at this point, I'm not in a position to vote for that, and I would hope that we would continue this great relationship we've had.
And again, if it is the discretion of this council to direct staff to use Quinto Annabelle or Loopster Nixon on a move forward basis where it does not have an injunction, impunge, or delay provincial priority, that would be the discretion of this council. Councillor Garwood, Councillor Fisher, Deputy Cabral.
Thank you, Mayor Coughlin. Just going backwards in regards to when we hired Loopster Nixon to begin with, again, what lawyer represents the Township of Springwater when we are picking one? First of all, I don't even know if council should be choosing the individual lawyer. But regardless, Loopster Nixon, fine. Whether I personally agree with their opinion or not, again, that does not need to occur. That is not a prerequisite. But when direction is provided to anyone that works for this corporation, that we no longer require their services because there isn't anything further to require at this time, but they disagree and they continue to come back and say, no, we're going to continue because we disagree. Again, regardless of who the firm is, when does that stop? When does the bills stop coming from any legal representative? I had a resident reach out today and said, we've probably spoken more up here about lawyers and legal opinions in the last 6 months than ever before. And that is the reality. So I do think we're getting bogged down here. I do think we are relitigating the past. Again, regardless of the opinion, my concern here is the documentation that we received. And I usually wouldn't discuss the fact that we received information directly from the lawyer, but I understand a member of council did share that with the media. So that's also been put out there in the public. So again, understanding the fact that that is the response from anyone that represents this municipality is concerning. And that's how I see this. I understand there's opinions in regards to the fact that strong mayors should not have been utilized for this, or there's opinions that certain motions have already been shared. From what I understand, the Moore motion, as which was referenced in the most recent legal opinion that we received, has already been shared with the province. Regardless of this council's direction, the province has that. So I don't think we need to litigate that anymore because the province has that information. The second piece, again, is focusing on notwithstanding any previous resolutions. It doesn't say any bylaws. It doesn't say anything of that fact. It says resolutions. And I understand there's been significant work put into this. I do not agree with everything with the strong mayors legislation. I've been the first one at this table from day one to say that it should be utilized in specific situations sparingly. But also we need to remember that saying that the mayor or any head of council can veto any opinion or any resolution is misinformation. That is not correct. That is not the case. If this council put a motion forward that had nothing to do with the provincial opinion, provincial priority, the mayor or any head of council could not veto that, or could not, they could vote against it as an individual, but not overarching across this council as direction. So again, we need to be accurate in which and when we are referencing this legislation specifically. Again, the province has outlined provincial priorities. We did not ask for this to be given to us. This is provided to 171, I believe, municipalities across the province. Almost 50% have access to this. I understand it's a different set of rules than all of us are used to working with. And when we started this journey 3 years ago, we had a different set of rules, and now we've had to adapt. But that's also part of the role and the responsibility that we have up here. So respectfully, if we're going to vote on something, I'd love to hear the resolution, and I'd love to vote on it, so we aren't, again, here till 11 o'clock at night.
Councillor Fisher and then Deputy Cabral.
Just to address lawyers' expenses, we find ourselves spending money on lawyers really because we found ourselves drawn into annexation. I would have loved to have spent no money on any lawyers, right? But we find ourselves seeking legal advice because it is generally the responsible thing to do. Actually, I would say it's always the responsible thing to do. And I also find it very, very hard to digest that the firing of Lubstra Nixon is somehow advancing a provincial priority. And I understand, well, as a mayor, you may not want a judicial review, but I would say that if the judicial review goes forward and it's exonerating, why wouldn't you want that? I also have to say that my motion came forward for an injunction and a subsequent judicial review, and that came forward. That was promptly vetoed using strong mayor's powers. I don't believe you can do that. Then, once Lubstra Nixon came forward and said they were ignoring this veto, then they were promptly fired. Optically, how can you're essentially firing a lawyer that's not going your way, a lawyer that was hired by all of council. So, and once again, they should not have been fired. You had no ability to fire them. And so when Councillor Garwood, you said, they can't just veto anything. Well, I think we're going into uncharted territory where we sort of have a mayor that feels she can veto anything. It's, again, precedent setting and should be very scary for any resident. Should be very scary, actually, for the Ford government as well, as this is being tested here in Springwater, and I don't think it's going very well.
And rather than spending hundreds of thousands of dollars on lawyer fees, why don't we just ask the province? Why don't we send them a letter and say, at any point has the province provided direction or opinion to this council? Is what I'm doing. If I can't do it, I can't do it. So let's just ask the province. Let's just ask the province. Let's send a message and just say, is this permissible? Is this? The last I heard was from, maybe I'll turn to the deputy, but in a meeting with the province, strong mayors was discussed. Deputy Cabral.
Strong mayors was discussed, and they left it up to you, Mayor Coughlin. Here's the dilemma I find myself in right now is we're going around in circles. And the fact of the matter is that this council, as a body, has the right to ask for judicial review on any decision made at any time about anything. And it says right here, not right here, but my words anyway, any person may apply for judicial review. The statutory right means a mayor's use of strong mayor powers does not prevent other entitled applicants, including council, acting by majority resolution from initiating the court proceedings. I just really want to step back to last Wednesday when that notice of motion that Councillor Fisher brought up. I would like to vote on that again. And then if the mayor would like to stop it, then that's up to the mayor to do that a second time. I think the issue was legal opinions all stating a different thing on whether you could or you could not use strong mayor powers. There was no direction to specifically use them. Unfortunately, I'm not going to say even unfortunately, they left it up to you to carry the ball. And my thing is, if we're here, and this is what it's about for me, is that there was a resolution passed. The message didn't go to the facilitator the way or the council had asked for it to go. There was another subsequent notice of motion resolution with respect to Mr. Lubstra Nixon engaging and finding out about looking at the legality and a judicial review of whether or not mayor powers could be used at that particular juncture, and whether or not, if that was going to be the case, to apply for it, whether or not an injunctive relief might be required. And Mayor, you turned around and you tried to quash that. And I'm suggesting to you that the Judicial Review Procedures Act does not give you the right to do that. It's an entitlement to counsel to be able to do that, or any other individual. So if you can't quash it when an individual does it, how is it that you're justifying quashing it when counsel as a majority does it? So I'd just like to say that that still needs to take place, and that's the resolution, or that's what I thought we were going to be here to do, is to talk about that. And if someone wanted to see that happen, again, because I don't, in my mind, see Loopster Nixon as not being our legal counsel for the express purpose of reviewing the decision made last week with strong mayor powers to see the validity and whether that use of strong mayor powers was faulty or defective. And I thought that's what we were here for. To discuss that, not necessarily that particular resolution of passing information on to the facilitator. I think anybody on council could probably sorry, did pass that on. I don't see that as an issue or problem at all, to be quite honest, because we were told if you want to contact the facilitator, go ahead.
And acting against the will of council, that's completely up to you whether you see that as acting as an individual or as a member of council. So
I apologize. Can you clarify how anybody was acting against the will of council?
when there is will of council and to the discretion, understanding that members of this council disagree that strong mayor powers can supersede a direction of council, it did. And a member of council then went
I think it's
against,
our obligation to make
it's
sure
fine.
that
If
you
it-
do have
and
the
if it was-
authority.
And if it was me that did it, would have been a very different discussion this evening. So I'm not here to, I don't know what we're here to debate. I do not know what's on the floor. I do not know what the resolution is. I did not call this meeting. So if someone would like to tell me what we're doing here, that would be great. Councillor Fisher.
Yeah, well, Mayor Coughlin, like I said in the beginning, it was a discussion about those two issues, and I think they are very pertinent. I do have a resolution to put forward. I'm sure you've already seen it. You made reference to it. But as far as I'm concerned, there needs to be I'll say a reinstatement, but in my opinion, they never should have been let go, Loopster Nixon, in terms of our legal counsel, as well as the vetoing of my motion from the last meeting. That should not have happened either. So I don't see either of those as being legal or valid. And so really, that motion should stand. And the retention of Loopster Nixon as our legal counsel should also continue.
And has that been shared with the clerk? Or, sorry, our deputy CAO?
Yes, it has. I sent forward a resolution.
And the resolution? Councillor Fisher, if you would like to read your motion, please.
Actually, would you mind, clerk, would you mind reading it for me?
If we can put it up on the
Yeah.
screen.
It is lengthy.
Councillor Fisher, a seconder, and then if you could read your motion, please. A seconder. Councillor Moore.
Whereas on May 7th, the mayor of, excuse me, this will be lengthy. Whereas on May 7th, 2025, the mayor of the Township of Springwater exercised the strong mayor's powers And bylaw 2025-042 has passed, authorizing the mayor to engage in discussions with the City of Barrie and the Province of Ontario with respect to the City of Barrie's boundary proposal. And whereas on September 3rd, 2025, the mayor of the Township of Springwater exercised the strong mayor's powers, and bylaw 2025-068 was passed, authorizing the mayor to include cross-border servicing for the Bayfield Street corridor in the discussions with the City of Barrie and the Province of Ontario regarding the City of Barrie's boundary proposal. And whereas the Township of Springwater Council authorized the retainer of Lubstra Nixon LLP and at the regular meeting of council on May 21st, 2025, the resolution C 245-2025 in respect of the City of Barrie boundary proposal. And whereas the Township of Springwater Council authorized Lubstra Nixon LLP to challenge the validity of bylaw 2025-093 and bylaw, to authorize the mayor and clerk to execute the boundary and adjustment restructuring proposal between the Township of Springwater and the City of Barrie, and the impugned bylaw by resolution dated November 5th, 2025, and provided a broad range of authority to the solicitor to take any and all courses of legal action that, in the opinion of the solicitor, are required to have the matter resolved, including, for example, an application to the courts to squash the impugned bylaw on the basis of illegality or application to judicial review. And whereas the Township of Springwater Council further authorized Lubstra Nixon LLP to seek an injunction to restrain the municipality and any other party from acting upon the impugned bylaw unless and until the matter is determined by the courts, and or to take any and all courses of action, legal action, that in the opinion of the solicitor are required to prevent any further action taken upon the impugned bylaw unless and until the matter is determined by the courts. And whereas the mayor of the Township of Springwater purported to veto confirmed bylaw 2025-091 in attempt to veto resolution dated November 5th, 2025. And whereas the veto is of no force or effect because the direction of council was by resolution dated November 5th, 2025, and the mayor can only veto bylaws in accordance with section 284.011 in the Municipal Act 2001 SO, whereas the mayor is issued mayoral direction MDIR 25005, November 8th, 2025, purporting to direct staff to issue written notice to Lubstra Nixon LLP confirming cessation of its engagement effective 12:15 p.m. on November 7th, as mentioned before, 2025, directing the firm to cease work immediately, and clarifying that the Township of Springwater will not be responsible for any costs incurred by Lubstra Nixon LLP on or after that time. And whereas mayoral direction here above is of no force or effect because Lubstra Nixon LLP is retained by council and not the mayor. And whereas the mayor is acting completely to completely stop council from taking any actions, including getting legal advice or having matters to dispute determined by the court. And whereas, there is a dispute about legality and validity of the mayor's acts and whose acts are valid, the mayor or the council's. And whereas, understanding the acts, the council and council are in dispute about the material and fundamental and go to the essence of the township, the very compensation of the township and the lands are in the township. And whereas the mayor is taking all steps possible not to have any of these issues determined in the court or in any independent body. And whereas, determination of who can validly or legally act on behalf of the township in issues fundamental to the township, where there is dispute without who can act in a matter connected to the good government of the municipality. And therefore be it resolved that Council of the Township of Springwater hereby confirms Lubstra Nixon LLP was retained May 24th, 2025 and remains retained to represent the Township of Springwater in all matters relating to the City of Barrie boundary proposal and associated proceedings, including judicial inquiry, provided for in paragraph 6. Council further confirms and, to the extent necessary, reappoints Lubster Nixon LLP to continue carrying out the directions set out in all council resolutions, notwithstanding any purported mayoral directions to the contrary. Council for the Township of Springwater rejects the City of Barrie's boundary adjustment proposal as presented and hereby informs the Minister of Municipal Affairs and Housing of its decision. The mayoral strong mayor bylaws are of no effect because they do not carry out the provincial priorities and because the inclusion of employment lands and the absence of any direction connection to the residential development of the township renders the proposal outside the scope of these priorities. The veto of confirmation bylaw 2025-091 and the mayoral direction MDIR 25-005 are of no force and effect because resolution dated November 5th, 2025, which authorized the engagement of Lubster Nixon LLP and the scope of legal action to be undertaken, was passed by council and does not constitute a bylaw subject to any veto under section 284.0.11 and the Municipal Act 2001. Excuse me. The mayor's authorization of veto is limited to bylaws that, in the mayor's opinion, interfere with the prescribed provincial priorities and does not extend to the resolutions or direction regarding the retention of external legal counsel. In essence, the mayor direction MDIR 2025-005 purporting to terminate the engagement of Lubster Nixon LLP is ultra varies the mayor's authority under part. Anyway, the Municipal Act. I'll let you read that. As the power, retain, and direct external legal counsel resides with the council and not the mayor. The council's previous directions to Lubster and Nixon with respect to challenging the validity of the impugned bylaw and providing a broad range of authority to the lawyer to take any and all courses of legal action that, in the opinion of the lawyer, are required to have the matter resolved, including, for example, an application to the courts to squash the impugned bylaw on the basis of illegality or application of judicial review, and to seek the injunction to restrain the municipality and any other party from acting upon the impugned bylaw unless and until the matter is determined by the courts, and or to take any and all courses of legal action that, in the opinion of the lawyer, are required to prevent any further action taken upon the impugned bylaw unless until the matter above is determined by the courts, stands, or for further clarification and direction includes the township. Do the following, unless the lawyer determines that only one or none shall occur. A, bring the application to squash the impugned bylaw and forthwith pursuant to section 273(1), the application, the Municipal Act 2001, SO 2001, C25. B, seeking the statutory injunction pursuant to section 273(4) of the Municipal Act, to prevent anything being done under the impugned bylaw until the application is disposed of. 6, the judge of the Superior Court of Justice is hereby required to conduct an inquiry pursuant to section 274 of the Municipal Act into a matter connected with the good governance of the municipality, and in particular of the following questions related to proper exercise of powers by the head of council under part of the Municipal Act. Excuse me. What practices and procedures should the township adopt to resolve disputes between the majority of council and the mayor about the appropriate uses of the mayor's powers under the section of the Municipal Act? What process would the township follow resolving specific questions regarding the mayor's exercise of powers in the Municipal Act? I'll let you read it. Excuse me, to facilitate the passage of bylaws. Was the mayor's exercise of powers in this part of the Municipal Act an attempt to veto resolution dated November 25th or November 5th valid? Does the mayor's veto of the confirmatory bylaw 2025-005 091 have the legal effect to on resolution dated November 5th, 2025. Sorry to put all of you to sleep. I know it's long. Was the mayor direction MDIR 2025-005 issued pursuant to section 284 3 part of the Municipal Act to attempt to end the retainer of the township's external legal counsel, Loopstra Nixon LLP, to prevent it from carrying out council's direction given through resolution dated November 5th, 2025. If the justice is of the opinion that the following questions are proper within the scope of the inquiry, was the mayor's exercise of the powers under the Municipal Act, under that section of the Municipal Act, to facilitate passages of bylaws 2025-042, 2025-068, and 2025-093 valid? Was the mayor's exercise of her powers under that section of the Municipal Act, excuse me, to attempt to veto the resolution dated November 5th, 2025 valid? Does the mayor's veto of the confirmatory bylaw 2025-091 have any legal effect on the resolution? Was the mayor's direction MDIR 2025-005 issued pursuant to section 284-3.3 of the part of the Municipal Act, to attempt to end the retainer of the township's external legal counsel, Loopstra Nixon LLP, and prevent it from carrying out council's direction through resolution dated November 5th, 2025 valid? Was it appropriate for the mayor to attempt to shield the use of powers under the part of the Municipal Act from judicial review and oversight by the majority of council? If the justice determines these questions are not properly within the scope of the inquiry, how can they judicially include the procedure route in doing so, both the township and in the courts? Sorry for the lengthy resolution.
There's another line on screen.
How should municipalities act in the future when similar issues arise in connection to the use of alleged misuse of powers under that part of the Municipal Act? Excuse me.
Can you put that back up on the screen again? I have many questions and concerns about this. My first, though, would, however, be this is in direct contravention to the direction of strong mayors. So if you're looking to overturn strong mayors, it would require a vote of 2/3 majority of council. I've also never, to my knowledge, been required to vote on something that appears to be a lengthy amount of questions rather than a resolution. So this is before us. If there's anything further, council, I'm assuming we're going to go to a vote. Councillor Garwood.
Thank you, Mayor Coughlin. It would have been nice to see this on the agenda, so we would be able to actually digest it. If we can receive a copy of this, that would also be ideal, understanding we're on the fly here, so it might not be possible prior to voting, but it would be ideal to see a copy of this. Through the mayor to the deputy CAO, can you please outline, and this is a question, not a statement, also just for clarity, around the process of voting for this motion, or I know there's been discussion earlier on in the meeting about re-voting on certain matters, understanding the existing direction that is in place.
Deputy.
Thank you, Mayor Coughlin. There are a few pieces. Speaking to the motion from last Wednesday, that was vetoed, specifically regarding the judicial review quashing of bylaw. The veto essentially nullified that motion. And so if that motion were to come forward, or the pieces of that motion were to come forward, it would be appropriate. It wouldn't be considered a reconsideration because of that circumstance. My apologies, because I did receive it from Councillor Fisher at the beginning of the meeting. However, once the meeting commenced, I wasn't able to read the motion. I believe there's a piece in here regarding the framework agreement and a statement that council ultimately votes down the framework agreement. Am I correct? That piece is a little more complex, as the framework agreement was approved through a mayor's strong mayor's bylaw. That one, I honestly, I would have to think about it for a moment just to be able to advise on that one further.
Deputy Cabral.
Could you, which piece on, I mean, there's a lot in here. I wouldn't mind actually having a copy of it so that I could actually have a look at what it says. But what Clerk Ainsworth, could you, what part is that in there? And is that a piece that's in there with respect to the framework agreement, or is it a piece in there with respect to the framework agreement in relationship to utilizing strong mayor powers to push it through as part of the question as to whether or not strong mayor powers would have applied?
Deputy.
Thank you, Mayor Coughlin. I have emailed it to all members of council and the CAO, so you should see that in your inbox momentarily. And I believe Councillor Fisher mentioned part 2. Council for the Township of Springwater rejects the City of Barrie boundary adjustment proposal as presented and hereby informs the Minister of Municipal Affairs and Housing of its decision. So that is in direct conflict to the bylaw that was passed at last Wednesday's council meeting, which would require a reconsideration of that bylaw.
And for clarification, reconsideration of the bylaw, or would it be the process in overturning a veto? Because I don't know what, like, this is speaking to both a veto and a resolution of council in one motion.
Thank you, Mayor Coughlin. It's part and parcel to both. There is parts in here that speak to the resolution that was vetoed, and then there are parts that speak to what was approved by council through bylaw. That piece would have to be a reconsideration. The council does have the opportunity to try to overturn a veto within 21 days of the veto being issued, with a requirement of 2/3, which for a council of 7, that would mean a requirement of 5 votes. That is the process to overturn a veto. Deputy Cabral.
Thank you, Mayor Coughlin. I struggle with, I guess, the veto piece, because I think going to the veto piece, because the issue here was whether or not the judicial review would look at the use of strong mayor powers in that particular situation. To then say that you're going to veto the strong mayor power decision when the reason that it was challenged was due to whether or not it could be used, and let the courts decide whether or not the strong mayor powers applied at that point, turn around and veto it, you're basically validating and discounting the reason that the motion was passed in the first place. This is very lengthy, but I think in a nutshell, this is to go back to where we were last week when that motion came forward and was passed. But I would like to review it for a little bit longer before I could, vote on it. It's very, very long and it's all encompassing. I was of the opinion that maybe the consideration would have been to simply revisit last Wednesday's motion to re-engage Loopster Nixon in line with that motion. But I'd like to reread this. Could we maybe take 5 minutes or 10 minutes?
Thank you. And before I do go to Councillor Fisher, Deputy.
Thank you, Mayor Coughlin. I also do want to advise that, as you see, there are a lot of parts to this. Without having time to review it, I may not have the answers that are required to deal with this procedurally on the fly. I do just want to caution council that I may not have all of the answers depending on where council would like to see this go. I do need some time to review this, see where council would like to go to be able to piece out some procedural advice on this.
Councillor Fisher?
Thank you. Just going back to what the deputy mayor said, you're absolutely correct. In a nutshell, it is going back to what to prior to the veto. And my motion would stand unvetoed, and we also would retain the services of Loopster Nixon. So yes, in a nutshell, that is it is a lengthy resolution, but that is really what it is.
So for clarification, this is attempting to undo a veto without going through the process that is laid out within the legislation. Councillor Fisher.
And also going back to what the deputy mayor said, essentially it was vetoed, but it should not have been. Again, it was using strong mayor's powers outside of the provincial mandate. So really, I believe that motion should have stood, and we should still retain the services of Loopster Nixon.
Understanding the complexity of this motion and also the urgency of calling a special meeting of council this evening and providing the clerk with this during the meeting, no staff, no legal, and no members of council have had any time. And this might be the most convoluted resolution I have seen. It might be in our best interest to defer a decision to Wednesday. When we have a meeting, we can have a meeting before the meeting and have an opportunity to deal with this, because as it stands tonight, there are points, to be quite frank, it goes item number 3, A, B, Roman numeral 5, D, E, F. There is a lot to absorb in this, and I think that to expect our staff in a 5-minute break or a 10-minute break to do the diligence or to allow myself to read this, I will leave it to council. Deputy Cabral.
Thank you, Mayor Coughlin. I guess my question is, this appears to me, Mayor Coughlin, to basically address the additional mayoral directives that followed that, in my opinion, would likely be defective or faulty as well. And that's what I want to review on here, is that. And I mean, I just asking for some time to read this and digest it a little bit better, and I think I would be in a position to vote on this, is all I'm saying. So if it's to revisit it and it passes, and Mayor Coughlin, you have your ability to do whatever you want again.
I'm going to go to Councillor Garwood.
Thank you, Mayor Coughlin. Through you to Deputy CEO Ainsworth, and I understand you might not have all the answers right now. Understanding that the legislation speaks to, I'm going to call it vetoing a veto, I guess that would be, with, you said 2/3 majority, so 5 members of a 7-member council. Why would we not go that route and table that compared to the resolution that is available to us today? And does the resolution today go against existing council direction? Because that is what I'm understanding from, again, an initial read of this, haven't had a second opportunity to look at it yet. So could you outline that process, please?
Yeah. Thank you, and then I do have CAO Ainsworth.
Thank you, Mayor Coughlin. So there is the process to override the veto, as I had outlined within Part 5, I believe Part 4, Part 5 of the Municipal Act regarding strong mayor's powers. However, council, should something be vetoed, it's as if it removes it from existence, which is why a reconsideration is not required, which means council could table another motion, which would be up to interpretation of the mayor to veto. So that piece, whether council goes to override a veto or submit a subsequent motion, it's not, the override isn't the, it's the intended process. However, it is not the end process. There are pieces in the proposed motion that are in direct contravention or conflict to a bylaw that was passed last Wednesday evening, and that is the piece that would, on first thought, first glance, without having absorbed everything, would require a reconsideration. I do need to put some thought into how a strong mayor's bylaw gets reconsidered. That is the piece I need to think about further. However, my recommendation would be that that piece would need to be reconsidered, as it's in direct conflict to direction that stands as of today.
Council, before we do move to the break that's been requested, I also remind Council that not too long ago we sat at this table, and the first time we brought forward the vote to vote on the framework agreement, members of Council asked for more time. And there was a deferral that moved forward. In this, in front of us, it actually speaks to redirection of that same vote that happened after a deferral. This is asking for a deferral for 2 days. I don't see the sense of urgency. There is a 21-day period for veto. I'm lost. This is an extreme amount of work to allow staff to provide advice on and to allow ourselves opportunity. But at this time, we can take that break. Councillor Alexander, Deputy Cabral.
Thank you, Mayor Coughlin. So essentially, why we're here, and this is my interpretation of the events that have occurred over the last almost week. We had the Moore motion put on the table. It passed. That motion met the provincial priorities. Housing. That's what was on that map. It was housing. That's what we put forward. That is what the provincial priority is. So then the next step is the framework agreement was voted down, which meant that motion is what was going to the province. That meets provincial priorities. The reason we're in this mess right now is because you then decided to veto. But I don't understand how you could veto, because that motion met the provincial priorities. The provincial priorities didn't say you have to take the framework agreement. That's another piece. That's a whole other issue. The provincial priority piece was met with Councillor Moore's motion. So the fact that you overturned it all is why we're in this situation. So this is my issue, is that you, in my mind, you didn't have the right to overturn it because it was meeting provincial priorities, just potentially not in the manner that you wanted them to be met.
And we will separate the two issues. Strong mayors was used to overturn the decision of council and previous decisions of council, which meant that the agreement from the corporation of the Township of Springwater was with the framework agreement proposed by the City of Barrie, notwithstanding anything else. So that is, then council had a motion with the league. Councillor Fisher's came forward. So there was no veto on Councillor Moore's. There was a veto on Councillor Fisher's.
But Councillor Moore's never got to the province.
Correct, because that was through a strong mayor bylaw.
Okay, so regardless of a bylaw or veto, it's the strong mayor power claiming they're being used for provincial priorities when the provincial priority was already met with Councillor Moore's motion. So I don't understand how you can continue, whether it's a bylaw, a veto, whatever, how you're continuing to use them when it is not moving forward a provincial priority. Councillor Moore's motion already did that. It is housing. It is not employment land. It is not annexation. It is housing.
The motion from Councillor Fisher spoke to that nothing would move forward until such time as we went through all of the steps of all of the courts. I am of the opinion that it is impeding on a provincial priority.
But that motion didn't come until you used the strong mayor power. If you hadn't used them in the first place, Councillor Fisher wouldn't have likely put the motion on the floor, because you were impeding what we were trying to move forward with, which was an agreement with Barrie. Everybody at this table was in agreement of moving forward with some sort of agreement with Barrie, just potentially not the framework agreement.
And while some may be of the opinion that that is an agreement with the city of Barrie, the city of Barrie provided us with one agreement. We were to vote on that one agreement. And instead of voting on that agreement, our council, members of council, came up with a plan B after the facilitated process was over. That was not what we were asked to be voted on. Councillor Alexander, go ahead. I am telling you that these are the reasons why. You're asking me for the reasons why and why I am of the opinion that. And I continue to provide you with my opinion. You disagree with my opinion. That does not mean it's not my opinion.
100% it's your opinion. I'm not
Correct.
saying it's
And
not.
I am providing that, and I am providing the timeline of everything that happened. It's on the website. The notice is there. I don't understand how there's a motion tonight to again try to undo everything that's been done. There is a process and a procedure set out in legislation that allows that to happen. If there's a veto by a mayor and council doesn't want that veto, you overturn the veto.
So all I
But
am saying is we could potentially remove ourselves from this whole situation if you revoke the strong mayor power that you probably shouldn't have used because they didn't meet a provincial priority. Councillor Moore's motion met the provincial priority. And with respect to reaching out to the facilitator, he told us to. That is not going against this council. He said, feel free to have a conversation with me. And the conversation I had with him is, would the minister be willing to look at other options? Because I wasn't comfortable with what was on the table, and I was told yes.
We have a request for a 10-minute break. Deputy Cabral.
Mayor Coughlin, yeah, we're beating the bush. But the reason we're actually here is because you decided to fire Loopster Nixon. And that's the reason why we're here. And the fact that you used your strong mayor powers was questionable based on all of the legal opinions. And that is why I believe Councillor Fisher brought forward that motion to have that looked at. And when you're talking about a time frame, there's also a time frame and there is urgency with respect to having the strong mayor powers looked at with respect to the decision that was made last week. There's timelines there too. And that is the reason why I believe Councillor Fisher put it forward. The 10 minutes is for me to review this because I get the sense here that this is basically from last Wednesday to look at all the other things that happened since then with respect to not sending the message to the facilitator, to vetoing the work with Loopster Nixon, and then turning around and terminating Loopster Nixon when Loopster Nixon was actually engaged by council as a whole. So that's why I need to read this, and then I'm prepared to make a decision.
Councillor Mark.
Thank you. Is there an opportunity if, because this all is circling around the use of the strong mayor's powers and whether they were appropriate, whether they weren't appropriate, I think, if I remember correctly, Councillor Fisher's motion was to move this to a judge to decide if there was an appropriate use or a not appropriate use. That's the only person that's going to solve this for us. So is there a desire at all to put the Loopstra-Nixon piece on hold, put it until we can at least get a judge to rule on the strong mayor's powers? I don't know what that would look like for us if that's another motion, but okay, I can see that you're.
Mayor Coughlin, the problem is that you need Loopstra-Nixon in order to do that.
sorry, correctly. Yeah.
Or a law firm.
I guess my thought on that too is we've had the same law firm for 2 years or longer, who knows all the intricacies of what it is that we're dealing with. I don't see moving to another law firm at the 11th hour a good move on our. I don't think it would bode well for us. I think in order for the township to be as well represented as they could possibly be, we stick with the same law firm that's been with us all this time. I don't know that we start over. Anyways, it's my opinion.
And by the law firm that's been with us all this time, you're speaking of Mascarin? No. So again, we have two legal opinions. And the idea that Mascarin has been brought on as part of this, or that he's our integrity commissioner, Mascarin has been here prior to 10 years? Providing he was the one who came and did our council orientation. He's the one that came and did our introduction to strong mayors. He's the one who provides the province with advice. So to me, it's like we have two countering off, and there's a group of people that like to listen to this one lawyer, and there's a group of people that want to listen to this lawyer. So to me, to suggest that we go one way or the other, Councillor Moore.
Thank you. And that is precisely the struggle I had when we were to vote on the first evening, was because we had two opinions that were opposing, but and then you say to your, who do you rely on? So I'm not saying get rid of either. I'm saying let a judge decide. I think we keep both, like we would have, but that. What an injunction does, I think what we were explained, is that it puts any decision on hold until that can be sorted out. And that can only be sorted out by the law firms that provided us the opinions. So I don't know how we fire one at this point, not the other. But the opportunity to let them both proceed in their lawyer way with the judge.
I see a lot of hands. If we have, there's been a request for a 10-minute break to dial. I don't even know what it is. But if council, we are at 8:05. Is it 10 minutes, Deputy? 10? 10 minutes. If we can reconvene at 8:15, that would be great. All right, council, we will resume our meeting, and at this time, I can turn to Councillor Fisher.
Yeah, actually, just discussions with the clerk. I can actually remove section 2 as it there is an issue with it, but the rest would stand.
As procedurally, I'm just going to walk where my head is at right now. As there are numerous points throughout this resolution that are contrary to existing resolutions with the corporation, I'm going to ask that in order for this to be voted on this evening, for myself, I will be calling this motion out of order. At that time, council will need to waive the procedural bylaw in order to vote on it. It doesn't prevent anything, it just allows the steps that I feel responsible to take place. Councillor Thompson.
Through the chair to Deputy CAO Ainsworth. So my understanding is the fact that we passed this bylaw last Wednesday night, that this is already, the framework agreement is already before the province with our approval.
Deputy CAO.
Thank you, Mayor Coughlin. The results of the bylaw from last Wednesday were communicated to the facilitators in the province.
Thank you. So, follow on. So my big concern here is, I expressed this last Wednesday night, I think it's really, tone deaf for us to spend more legal fees on this when it's already before the province. Province will likely have a decision made on this, and it'll probably likely go before the floor of the province for a vote in the next few weeks. That would be my guess, long before this judicial review. And Loopster Nixon has already spent $82,000 for a couple of opinion pieces. That's more than a lot of our residents make in a year. I think it's tone deaf in these times to waste this money and spend more money on legal opinions that really aren't going to make any difference. They might validate our opinion and give us some political help in the next election, that we'll be able to say, oh, we fought this, and my opinion was the same as a lawyer. I have no interest in spending taxpayer monies for that, for a political purpose. I just think that this motion that was presented tonight really fights all the battles that were the opinions that had gone on for the last 2 years. And I thought we had come to some kind of conclusion last Wednesday. And here we are again at some special meeting that was an emergency meeting that our clerk here tonight didn't even have the courtesy of having the motion before the meeting. The person presenting the meeting had a difficult time reading it. It seemed like he didn't even know what was in the motion. It was a very lengthy motion, and again fights all the battles that we've been discussing here for the past 2 years. So I had to adjust my schedule tonight to meet this short time frame. I found out at 9 o'clock this morning. Councillor Fisher did have the courtesy to send me a text telling me about it. I tried to call him to find out what the rush was, what the emergency was. He didn't pick up. Or I guess my question to him, what is the emergency tonight, and who wrote this motion for you?
I have a response, Councillor Fisher and Councillor Moore.
Yeah. Councillor Thompson, you say that it's before the province and basically throw your hands up. I can remember about a year and a half ago you saying this would be done in 3 months. I also believe that our legal team should be able to do their job without being fired, essentially, because council did what was asked of them. Also, too, the assertion that it's tone deaf. Well, the expense that has been put forward through this annexation process, and frankly, the legal consultation, Mr. Thompson, you've been an advocate for annexation from the beginning and really a lobbyist for it. So this expense, Mr. Thompson, is largely on yourself. I didn't want from the very beginning annexation. I didn't even want to discuss it. Certainly, I didn't want to go down this road. So that's also, I have to say that emergency meetings do happen. Sometimes budgetary meetings go over. That's part of the job. So I'm very sorry that it was an inconvenience for you tonight. But I also believe that this is very important. The use of strong mayor's powers in this fashion is cause for concern. It's certainly cause for concern in the community that both you and I represent. So I'm sorry for the inconvenience of you coming in tonight, but I still believe that it was the right thing to do, and it needs to be dealt with in a timely fashion.
I believe I would follow on, and then Councillor Moore.
Thank you again, and thank you for putting words in my mouth again, Councillor Fisher. I never once asked for annexation. I knew from the start, the province has said that there is going to be a boundary adjustment. From the start, I felt important that we be part of the process, that we not be an ostrich and stick our head in the sand, and that we actually have the courage to do the job, the thing that we were elected to do, and actually stand up and have a productive part and role. I wasn't comfortable with the City of Barrie and the province meeting with us on the sidelines. I've been very clear from the start, we should have been part of the process.
Councillor Moore?
Thank you. Thank you, Mayor Coughlin. Two things. Important to note, too, that we followed the advice of our solicitor from day one, who also said it would be best for us to be part of the facilitation process. So we went down that road because that's what we were advised to do, too. The clause that Councillor Fisher is offering to remove, I would ask that Clerk Ainsworth or Deputy CAO Ainsworth, could you please read which one that is for me, and what that will do to the strong mayor's powers? Not overall, sorry. I mean,
Deputy.
Thank you. Clause 2 that Councillor Fisher referenced removal read, Council for the Township of Springwater rejects the City of Barrie boundary adjustment proposal as presented and hereby informs the Minister of Municipal Affairs and Housing of its decision. That would require a reconsideration of council, as it's a bylaw that is duly approved by this council last meeting. Which is why it would be problematic within the motion itself.
Councillor Moore?
Other than that clause, then, would you be satisfied to move forward with this? Would this be then addressing sort of everything else except for the framework agreement?
Deputy CAO?
Thank you, Mayor Coughlin. I would not be able to provide an answer on that. There are a lot of pieces to this that, to be quite honest, are varying opinions of the same legislation. Just as an example, point 4, the veto of confirmation bylaw 25091 and mayoral direction 005 are of no force and effect. That is not for staff to comment on. That is an interpretation of the mayor using strong mayor's powers in a certain manner that some members of council are not in agreement with. It is not something for staff to be commenting on. There are quite a number of pieces to that within this motion that I would apply that same comment to.
Okay. Councillor Moore?
Thank you. It seems to me the biggest sticking point is the removal of our legal representation. So I would waive procedural bylaw to allow us to continue to use the services of Loopster Nixon until such a time that this at least can be sorted out. I'm not comfortable because I don't understand why we are removing them. So I say reinstated, but I'm half of the opinion that they haven't actually been removed as our representation. So I think that we could reinstate them for now. And I don't know. I just say reinstate them.
I had Deputy Cabral, Councillor Garwood.
Thank you, Mayor Coughlin. I'm just kind of reviewing up at the top again, and was wondering at that time whether number 2 should be up at the top, because then it was followed by something else. But I also spoke with Clerk Ainsworth, and I'm okay with it the way it is.
Councillor Garwood.
Thank you, Mayor Coughlin, and through you to council. I guess my only confusion regarding our solicitor and that piece of the conversation is, should council move forward to quote unquote reinstate? I'm not quite sure what they're reinstating them for the purpose of. Which task are they doing? What are we tasking our solicitor to complete, understanding that while the majority of this council is of the opinion that strong mayors through the veto should not have been utilized on Friday, the veto still exists, whether the opinion is or is not that it should have been utilized. So again, reinstating Loopster-Nixon, fine and dandy, but again, what is the purpose of their actions at that point? So I'm not trying to be disrespectful, Councillor Moore. It's honestly a question.
Thank you. I think the last direction that we had given them was to move forward with Councillor Fisher's injunction and judicial review. And so I think that is what they returned back to us to say that they were proceeding with, based on the fact that it was council that hired them, not council that had let them go. So I say we allow them to go down that road and at least sort out the piece for us with the strong mayors, whether or not we can use the strong mayor powers in this situation. Hopefully it doesn't take very long. I remember with our legal opinion, he did say it could be done fairly quickly.
Councillor Garwood, and then I do have Councillor Fisher.
Thank you, Mayor Coughlin, and through you to Councillor Moore. Thanks for that response. Again, while I completely understand what you're saying in regards to the injunction and the judicial review, from what I understand, that no longer exists. So again, it's fine to have the solicitor, again though, unless the veto is overridden, I just don't understand what we're tasking them to do, because if we pass a motion that says for them to be reinstated and continue with the judicial review and the injunction, that directly goes against existing council direction, which is through the strong mayors legislation. So this is the circle that we end up in, and then also understanding whether we can or cannot use strong mayors. Again, I think we've been having that same conversation since May, right? We're going to continue to have that same battle for the next 360 some odd days or 50 some odd days throughout this term. We're never going, unless the province comes out and specifically inserts themselves and says, yes, you can, or no, you cannot. Again, whether or not we're listening to that, as they are the authors of the legislation does speak to the opinion of the head of council. You don't have to agree. Everyone, 6 of us, could disagree with that perspective, but again, that is what the legislation speaks to. So I just see us in a procedural loop here, going around and around in a circle. I understand that there was a deferral that was not tabled, but suggested earlier on. I'm suspecting there isn't an appetite to do so. But in the interest of us being here, going around those loops together, I do see it as an appropriate path forward for staff to be able to review the matters that are not political, as the Deputy CEO noted, and provide guidance regarding the procedure on how to proceed. I'm not suggesting that this be squashed. I'm not suggesting that this council should not vote on this. It's been tabled. That is how the these things work around the table, whether I like it or not. It should be voted upon, and the public should know how we vote. But we should also do so with a sound mind and understanding what we're voting on. That's all I'm asking.
Councillor Fisher and Deputy Cabral.
Yeah, I'll make it brief because I would like to vote on this tonight. Once again, I believe the veto should not have happened. It does not provide, does not fulfill the provincial mandates of building more homes faster. So, in addition to that, firing our legal representation, really because I feel that they were continuing along with the same resolution that was passed, despite they essentially were ignoring the veto because they deemed it to be unlawful. That's why they were fired. So we do need to reinstate them. They should not have been exited in that fashion. And well, I'll let the deputy mayor speak and then call the vote.
Deputy Cabral.
Thank you. I think for clarity, you have to understand what a judicial review actually does. And this is a basic guideline that the province has put out. It's from the ontariocourts.ca. A judicial review is a process by which courts make sure that the decisions of administrative bodies are fair, reasonable, and lawful. The Divisional Court hears applications for judicial review of decisions as set out in the Judicial Review Procedure Act. What kind of decisions can be reviewed? Decision makers whose authority and powers exist by virtue of statute, such as strong mayor powers, are subject to judicial review. Administrative bodies whose decisions may be reviewed by the Divisional Court include administrative tribunals or government decision makers whose responsibility it is to decide any person or party's legal rights or their eligibility to receive a benefit or license. The decisions of private actors are not subject to judicial review. And then there's a few examples there. But basically what it does is it looks at a decision and reviews it for its legal adherence to the legislation that it's being drawn from.
The vote has been called. Prior to that, as there are numerous points within this motion that are contrary to existing resolution of this council, as there are numerous points at the end that are actually questions, not statements, not direction. I will be deeming this out of order. And at this time, if there is a will to vote on this evening, it would then require waiving of the procedural bylaw. Councillor Fisher moving to waive the procedural bylaw.
Correct.
A seconder for that, please. Councillor Alexander.
Thank you. I'm just going to make one last ditch attempt. And is there an opportunity to hold the Strong Mayor's bylaw passed on Saturday to absolve Loopster Nixon? Is there an opportunity for you to waive that for a few days until this can be digested by all of council?
Speaking specifically to the veto.
Thank you. To Saturday's direction, the bylaw passed Saturday.
To allow.
No? Okay. Anyway, nobody's agreeing with me. Okay.
Are we voting on procedural?
Yes.
Sorry.
Yes.
Sorry. Okay.
So I do think if there's, again, not that I want to stay here all night, because I certainly don't, but if we can avoid this through Councillor Moore's suggestion, I'm willing to have that conversation. Because I think that is why we're here right now, is the surprise mayoral direction on Saturday, that we were ceasing and desisting with a lawyer and the work that they were doing. So again, if there's no appetite for that, then that's fine, but I do have an appetite for that if Councillor Moore is suggesting it.
And I will walk that procedurally. Deputy Cabral. No, I was just going to say. No, I was
I
just going
was
to
just
say.
gonna
I
say-
will address that, but I was going to hear
Yeah,
your
I
comment
was just
first.
going to say, Mayor Coughlin, that's exactly what this is about, is to put Loopster Nixon back on the job as council originally asked them to do on Wednesday. Unfortunately, when Saturday rolled around, Mayor Coughlin used your strong mayor powers to put that out. Once on Friday, and then again on Saturday to actually terminate them. So it was two different things. One of them was for them to not continue the work. The other one was then to terminate them. So this basically is to put them back on the job. And I just assume vote on it and move on, to be quite frank. And if it passes, it passes. If it doesn't, or if you choose later on, Mayor Coughlin, to veto it once again, that's your prerogative, and I understand that.
Councillor Garwood, and we do have a motion is to waive the procedural bylaw. So, Councillor Garwood.
Thank you, Mayor Coughlin. So again, through you to the Deputy CAO, while the Deputy Mayor is indicating that this motion in front of us today puts Loopster Nixon back on the job, don't we have existing direction that speaks to the contrary? So again, not speaking about who is right or who is wrong. I'm speaking to the fact that I want the public and this council to be aware of what we are actually voting on. It's really sad, actually, that we are sitting here all confused about what the motion is, which could have been completely resolved if A, we would have had it on the agenda, B, we would have had it before it was tabled on the floor, and C, an opportunity to have a deferral to actually be able to review it for 36 hours before we meet back here once again for another meeting on Wednesday evening. But can we get some clarity around, if this passes, what actually occurs?
Deputy CAO.
Thank you, Mayor Coughlin. There are two mayoral directions decisions that, unless rescinded by the mayor, are still in effect. One is regarding the veto of the resolution from Councillor Fisher on November 5th. The second is the one from November 8th, which speaks to the dismissal of Loopster Nixon and a few other points. Those mayoral directions stand unless rescinded by the mayor or otherwise advised by another body, usually the courts.
And further to that, there is an opportunity through the 21-day window where members of council can have a vote to overturn the veto. That would be another way to remove that. However, this is the path that council has chosen. We have a motion to waive the procedural bylaw in order to vote. Council, all those in favor of waiving the procedural bylaw? That has carried. And at this time, we do have a motion on the floor from Councillor Fisher, which has been seconded by Councillor Moore. Deputy Cabral.
Just for clarity's sake, this is about a judicial review. It's not about whether or not the vetoes exist. They were used with strong mayor powers, and this is about recognizing whether those strong mayor powers were used properly. That's what the judicial review is designed to do, is to address that. And the courts may agree 100% that they were used 100% in alignment with the legislation, or they may say that they did not follow the legality of the. So you're asking, what does this do? That's basically what it does. So I mean, we've called.
And the vote has been called, but just for clarity, because it often happens at this table that one member of council says one thing and then another member of council says another thing, and then the public is confused. Should this motion pass, which has been deemed out of order, nothing changes. There is no direction to move forward with a judicial review by this council. Council, anything further on the motion? Councillor Moore.
Sorry, I didn't know that, so thank you for explaining. And so I'll go back to, would there be a desire then to waive the bylaw that you passed Saturday to give us opportunity to digest all of this till Wednesday? Or no, you want us to vote on this tonight and truly,
No,
I'm sorry.
Calling the vote right now.
Okay,
If somebody doesn't want to vote for it, let them not vote for it. If they want to vote for it, let them vote for it. If it's out of order, it's out of order. If the mayor decides she wants to veto it a second time, that's her prerogative. Sorry, Mayor Coughlin. I apologize.
thank you. The vote was called and then the deputy spoke and you didn't have a problem with that.
Absolutely. Mayor Coughlin.
Councillor Garwood.
Thank you. So I guess the rules only apply to 6 members of council, but the deputy mayor gets to make his own up consistently.
And
I'm
okay.
going to continue
Ladies
to speak.
and gentlemen,
Deputy Mayor
members of council.
He's out of order now, for sure. I kept my mouth shut last time.
Actually, if you'd like me to go back and reread all the things that were said this evening, because it comes from one member of council does not.
Fair enough.
Thank you.
Respectfully.
The vote has been called. Members of council, all those in favor? The vote is for. Opposed? 3. Members of council, that has carried. We will now have confirmatory. Mover and seconder for the confirmatory bylaw, please. Councillor Fisher, Councillor Moore, that the bylaw 2025-095 to confirm and adopt the proceedings of council at the special meeting held on November 10th, 2025, listed herein, be signed and sealed by the mayor and clerk. All those in favor? And that has carried. And adjournment, please. Deputy Cabral, Councillor Garwood, that the special meeting of the Township of Springwater does now adjourn at 8:49 p.m. to meet again in regular session on November 19th, 2025 at 6:30 p.m. All those in favor? And that has carried.